Do you respond? How do you respond? And what do you respond with when sued for debt? Brought to you by yourlegallegup.com, your advantage if you're being sued by debt collectors. We talk elsewhere about what constitutes valid service of a lawsuit, and you should check out that video and article if you have any questions about whether you've been served. The link is in the video description below. I'll also be referring in this video to several other videos, and all of the links will be below in the description. We also discuss elsewhere whether you should respond to a debt collection lawsuit you find out about if you have not been served the complaint yet. To boil that down to its most essential point, if you have not been served at all, you hear about the suit from a neighbor or look your name up in court files, or a lawyer sends you a letter saying you're being sued, to name some examples, we suggest you take no action if you don't have a lawyer. If you do have a lawyer and the lawyer thinks it's best to get on with it, that might be a good idea, but as a pro se defendant, you won't be able to shut the case down the way a lawyer might. Let them serve you if they can, but you have no obligation to help with that process. You don't have to go down to the sheriff's office or call the firm suing you or its process server. See if they can get you, and if they can't, the case will be dismissed against you. It actually happens a lot, although not a statistically huge percentage of cases. If you go this route, you will want to keep an eye on the court docket to see if, whether or not they have served you, they claim to have served you, and that brings up a special issue that we discuss elsewhere too. If you do get served, your next question will be how to respond. If you fail to respond at all, the other side will get a default judgment and start trying to get your stuff, so this is probably not a good idea for you. You'll need to answer or file a motion. To answer the question of which, you should first consider what kind of court you're in. Are you in a small claims court, sometimes called a magistrate court, or are you in a real court? If you're in a small claims or magistrate court, see our video and article on that. Assuming you're in a real court, you'll need to do two things right off the bat. First, find your state's rules of civil procedure and look up the part about service of process and motions to dismiss. Some motions to dismiss have to be filed before you answer the petition. Find out if you have one of those. The petition is vague, names the wrong person, or violates certain procedural requirements some states have for debt collectors. And by the way, I'm not suggesting that filing a motion is always what you want to do, not by a long shot. If you have one of the motions that has to be filed before answering, you'd be waiving your right to file the motion if you answer first. One of those motions is whether or not you were legally served. If they claim you were served, but you have some reason to dispute that, you probably need to bring what's called a motion to quash service before you answer. Answering will be regarded as your consent to the court's jurisdiction. If none of those concerns apply to you, you will need to answer the suit. In some states, they have what's called a verified petition, which means that someone swore to the truth of the allegations. If you have that sort of petition, you will need to swear to your answer in the same way, and this means getting a notary public to witness the document, and they will have one too if they've filed a verified petition. It'll also be called a verified petition, but this is rare. In most instances, the petition is an ordinary one signed by the lawyer for the debt collector. If that's what you've got, you will simply want to deny almost all the paragraphs one by one in the petition. Don't go to absurd lengths and deny your name or address if those are correct, but you should generally deny all of the substantive allegations. The legal effect of your denials is to say, prove it. In some states, you file what's called a general denial. You can file that, which does in one sentence what I just suggested. And by the way, if they provide a form for you to check boxes, you don't have to do that. You can create your own form to make sure it says what you want it to say. And you should if there's no box to check, which says exactly what you want to say. If you think you have a counterclaim against the person suing you, you will want to add that to your answer. We discuss affirmative defenses elsewhere, and you'll find the link in the description, but in general, they are facts that even if the debt collector says what the debt collector says in its petition is true, would mean that you don't owe them the money. Most typical of these sorts of defenses are some sort of agreement to settle or address a claim, or the passage of too much time, called the statute of limitations. This is not a feeling that you have. It's an actual law. Find out for the claim that's being made against you what the statute of limitations is and see if they've violated it. Probably too late. The essence of an affirmative defense is that you bear the burden of proof and showing that these factors exist. Finally, let's talk about demanding a jury. Our position is generally that defendants should ask for jury. We discussed this in greater length in our article and video on juries, but if you think you want a jury, as we recommend, you need to find out how your court and state require that you demand one. Best to do that before answering, since timing might be important to protect your absolute right to a jury trial. In federal court in some states, it's enough to say it as part of your answer, and in some states you have to make a separate request by separate pleading. Find out what you're required to do and do that. If by chance you're just finding out about this after already starting to defend your case and having already filed something, that doesn't mean it's necessarily too late. If you have a right to a jury trial, the right is absolute when you raise it in the proper way and time, but even if you don't do that when you should, the court should normally grant your request anyway, absent some sort of misbehavior or the passage of too much time. And they are required to be liberal in their interpretation of what's too late because the courts favor jury trials. So if you're too late, even if you're too late, you should go for it if you want one. You'll notice I've said you should find out some things, from procedures to rules, before you even decide whether you need to answer or not. And considering whether you might want to file a motion of some sort, you'll need to do some legal research. We have information on how to do that on our site, and the first thing you should research is what kind of claim they're making against you and whether they've alleged enough for it to state a claim. This is not a question of whether they attached evidence, but whether the allegations amount to a proper claim against you and what kind of claim they raise. You'll also want to find out whether they have any special pleading requirements for suing you on a debt, as is often the case by state law. That would be a question of your state's pleading requirements for debt collectors. For more help, follow the links in the video description below and check out our site. We recommend you join us with a 2020 membership, as this is both the cheapest and most comprehensive plan we offer. It's the best deal. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com